Alexander. С вашего позволения, я прошу внимания. Let me ask for your attention, please. The institution of Ombudsman, or for that matter, as the Council of Europe defines it, the Office of the High Commissioner for Human Rights, has existed for about 200 years in the Nordic countries in various formats, under different regimes. And the idea of environmental protection, let me also remind you, was born in the Nordic countries where people were inclined to treat the nature sparingly. The Institute of Ombudsman is the epitome of culture that Russia has now gone a certain path by introducing in this country. The difference may be, although it is quite a recent institution, for both the Russian society and the Russian government, it depends not only on the formal things or the formal criteria, but also on the actual characteristics of the person who occupies this position. From this standpoint, the personality of the person who holds the office is of great importance. I have the privilege of being a close friend of Vladimir Lukin, and I think that what they have done as an institution in this country are quite important. And we do hope that Ella Pamfilova will also be successful in her position. But as I said, the actual personality is very important. But the fact that Ella Pamfilova is a very active person is true. Mr. Lukin was a great ombudsman. So I think that this session is particularly important both as an institution and as the history of people who have held this office. I would like to express my gratitude to the Kingdom of Norway, which has been a supporter of our project and has mediated in inviting our esteemed expert for this session. I hope this will be a very interesting and important, very important session, and I will give floor to Arne. Thank you very much for being with us.
Спасибо. And thank you very much for the invitation to come here and to speak to you. It's a great honor, and I'm also looking forward to hear questions or comments to my speech. Myself, let me first introduce myself. My name is Arne Fliflet. I'm a lawyer by profession, I'm sorry to say. Some hate lawyers. I know, but lawyers can also be quite useful in some respects. But many of my colleagues, former colleagues as ombudsman, were very skeptical to lawyers. But as I shall come back to when in my speech, I will tell you about why the legal profession or the legal background is important for the Ombudsman in the Nordic countries. Before I became Ombudsman, I was Ombudsman appointed by Parliament. It is the Norwegian Parliament, the Storting, appointing the Ombudsman. The parliamentary period is for 4 years, and the Ombudsman is therefore appointed for 4 years. But he can also be elected again and again and again. And I was elected and re-elected 6 times. So I finished my mandate in June this year, after 24 years of service. Before that, I was a barrister, an advocate in private practice. And before that, I was an attorney or a lawyer in public practice. I also been a public prosecutor and a teacher of law at the faculty of Oslo. And we have a special institution in Norway. As young lawyers, we can be deputy judges, and I was also a deputy judge in my younger days. So I had a different kind of experience before I was appointed Ombudsman.
Next time I will introduce you with pleasure.
Okay, thank you. I shall give you an outline of this Ombudsman institution. I shall myself be the PowerPoint. I have no PowerPoint there. But I shall first give you some remarks on the name of the Ombudsman and the history and the different cultures in the Nordic countries, the East and the West, and the legal schemes and how they work, and also the relationship between the Ombudsman and the courts, and some few words about the Ombudsman and human rights. This word Ombudsman has spread all over the world and is very popular. And it also, when it was introduced in Scandinavia, it was very popular. So, and in Norway, it resulted that we had lots of ombudsman institutions. So when the children issues came up, well, what shall we do about that? The politicians asked. Oh, let's have an institution of ombudsman for children. So we have an ombudsman for children. And discrimination questions came up. So what shall we do with the discrimination issues? Well, let's have an ombudsman for that. And we have an ombudsman for discrimination, for gender equality, for racial equality, and sexual equality, and all that. And consumer protection, and patients in hospitals. So there are special ombudsmen for all these tasks. But there is only one parliamentary ombudsman with special tasks. This is the institution I shall talk of. Scandinavia, Denmark, Norway and Sweden are 3 independent countries with different systems of government and administration. Seen from the outside, the Scandinavian countries in the Nordic area are perceived as countries where the similarities are more conspicuous than the dissimilarities. The Nordic countries also include Finland and Iceland, as well as the Faroe Islands and Greenland, which have close affiliations with Denmark. These countries have different public administration systems, and their ombudsman schemes are also dissimilar. In this address, I would like to explain the similarities and differences in public administration and in the ombudsman offices in the Nordic countries. In order to understand the systems they must be seen in relation to fundamental characteristics in the different countries, in the constitutions, public administrations, and the courts, and we should also include law studies and the legal profession in the individual countries. As mentioned, in 1809, the 200th anniversary of the institution of the Ombudsman was celebrated. This year, we celebrate the 200th anniversary of the Norwegian Constitution. Actually, the first Ombudsman institution has its roots even earlier, at the beginning of the 18th century, when the Swedish king, Charles XII, was in Turkey fighting wars. He needed a representative in Sweden who could make sure that senior officials and office holders fulfilled their duties in proper manner. The king therefore appointed his own ombudsman. When the new constitution was established in Sweden in 1809, the Swedish parliament, the Riksdagen, created by election, also wanted an ombudsman, and the office of Justice Ombudsman was thereby established. The remit of this ombudsman was to ensure that senior officials and civil servants acted in accordance with the laws of the country and performed the official duties to which they were entrusted. From 1814, Norway was in union with Sweden, with a common king, a personal union. That was a French marshal who was king of Sweden at that time, one of Napoleon's old friends. But he became king of Sweden. He never learned Swedish. He always spoke French. So the king's court had to adapt to that, which caused problems, of course. But in 1822, the king attempted to establish a type of ombudsman scheme in Norway, a general procurator, who could be compared with the Swedish king's ombudsman, a chancellor for justice. And he was appointed in 1822, but he gave up after 3 years in 1825. Now, many years later, after the Second World War, there was a requirement for strengthening the guarantee of due process of law following 5 years of occupation and Nazi regime. An expanding public administration also contributed to the need for strengthening the legal and procedural rights of the citizens. A legal commission proposed a law on public administration with rules about how administrative cases should be handled. The Commission also proposed a law on Freedom of Information Act, with rules about public documents. And finally, the Commission proposed the establishment of an institution of Ombudsman for Public Administration. Proposals for an ombudsman scheme were put forward both in Denmark and Norway before that. The Danes included a provision concerning an ombudsman scheme in their constitution of 1953. In Norway, progress was slower. A proposal for an ombudsman scheme submitted at the National Assembly of the Liberal Party in 1949 was given a less than enthusiastic reception. This was probably connected with the general impression that an ombudsman of Swedish model would be a thorn in the side of senior officials and civil servants. For this reason, it was perhaps not so strange that the idea was received with skepticism. The Swedish parliamentary ombudsman was, in fact, an institution established to ensure that senior officials and civil servants fulfilled their duties, and the ombudsman also doubled as the public prosecutor in cases brought against such officials. As this perspective was also emphasized by those proposing to establish an ombudsman scheme in Norway, it is understandable that the proposal received little support. During the German occupation, senior public officials and civil servants did in fact play an important part in the active Norwegian resistance movement. When the frame of reference for an ombudsman scheme was amended, with citizens' rights taking priority as the most important part of the ombudsman scheme, the skepticism and unwillingness receded, and in Denmark the Office of Ombudsman was established in 1955, and 8 years later the Office of Parliamentary Ombudsman was also established in Norway. But we were the fourth in the world. The first was Sweden, the second was Finland, the third was Denmark, and the fourth was New Zealand in 1962, and we had it from 1963. So the Ombudsman institutions in the Nordic countries can be divided into East Nordic and West Nordic policies. In the East Nordic Ombudsman schemes in Sweden and Finland, it is mainly government departments and officials that are under scrutiny. In the West Nordic countries, citizens' rights form the basis and the frame of reference for the schemes and the control of public administration. A common feature of the schemes in the Nordic countries is their firm roots in the legal system, the legal nature of the schemes, which are closely linked to the courts, the legal system, the enforcement of law, and the legal profession. In the Nordic countries, parliamentary ombudsmen must be members of the legal profession. In Norway, the Ombudsman Act specifies that ombudsmen must have the same qualifications as Supreme Court judges, and all parliamentary ombudsmen are members of the legal profession with experience as judges or lawyers. In Denmark, ombudsmen have been elected among professors of law. In Sweden and Finland, parliamentary ombudsmen are always judges of persons having a background from the courts of law. And in other words, there are close ties between the ombudsman institutions and the courts in the Nordic countries. The Nordic and West Nordic ombudsmen's meetings are conferences for the legal profession. It is also important to emphasize that in Sweden and Finland, the courts of law are under the scrutiny of the ombudsman. However, the ombudsman will only deal with procedural matters, not the substantial or material questions. Finally, it is fair to say that today also the citizens' rights are more in focus than the duties of the officials. We have re-examination schemes in all the Nordic countries. There is an important dividing line between Sweden and Finland on the one side and Denmark, Norway and Iceland on the other side with regard to the legal authority exercised by public administration and the re-examination schemes. Sweden and Finland have separate public administration courts that pass decisions in individual cases. In the West Nordic countries, we have only the ordinary courts of law, and re-examination of individual decisions take place in administrative bodies and in administrative forms. In the West Nordic countries, therefore, the Ombudsman fills the void represented by the absence of administrative courts. In Sweden and Finland, where the administrative court system is established, the Ombudsman has therefore a different role to play. The parliamentary ombudsman in Sweden and Finland monitor case processing and the duties of government officials, but do not re-examine the substantive aspects of the decisions passed by public administration. These matters are dealt with by the public administrative courts. In the West Nordic countries that have only the ordinary courts of law and no separate administrative court system, the ombudsman can be regarded as a supplement and an alternative to the ordinary courts of law. The firm entrenchment of the ombudsman scheme in the legal system and the legal authority attached to the system means that although the ombudsman only has the right to voice an opinion, this will invariably be complied with in practice. The Norwegian ombudsman system is built on law, and the investigations made and opinions rendered shall build on valid current law. However, the ombudsman is less formal and more flexible than the courts of law. He has also a right to express his opinion, which is not legally binding, but, as I said, has substantial authoritative strength. He may express his concern, his doubts on law and facts, and may also criticize decisions for being unreasonable. The citizens accordingly have in the Ombudsman system alternative means to correct faults and deficiencies in public administration. Another special feature that should be mentioned is the Ombudsman's supervisory role with regard to the courts and judges in Sweden and Finland. In the West Nordic countries, the courts are expressly exempt from the remit of the Ombudsman. In Sweden and Finland, relationships between the Ombudsman and the judges can for this reason be somewhat strained. But in view of the fact that both institutions are firmly rooted in the judicial profession, the conflict of interest is perhaps not so great. However, the clear-cut dividing line between the Ombudsman and the courts in the West Nordic countries no doubt contributes towards less tension in the relationships between the courts, the judges and the Ombudsman. There can be an advantage in this situation as the Ombudsman forms an opinion on substantive law issues that are also brought before the courts. And that happens from time to time. But up till now, there has been no conflict between the courts of law and the Ombudsman. The courts of law have in nearly all cases upheld the decisions or the recommendations of the Ombudsman. There can be an advantage in this situation as the Ombudsman forms an opinion on substantive law issues that are also brought before the courts. It can be an advantage that the relationship between the institutions is not characterized by mistrust and jealousy. And that is a problem. And let me add, outside my manuscript, that a key word of the Ombudsman institution is trust. And Ombudsman is an old Norse word, and it means a trusted person, a man who is trusted with a commission from another. It could be the King's Ombudsman, but now it is the Parliament's Ombudsman, the trusted person. And as the Ombudsman can only render his opinions, he cannot make legally binding decisions. The Ombudsman's opinions must be respected by the government authorities, by the public administration. So the Ombudsman should have the trust of the public administration. But it is also important that the Ombudsman has the trust in the people who use the institution. So this balance is can from time to time be difficult. And I must say, in my experience, I was not always met with trust. I was sometimes met with skepticism. And one important task of the parliamentary ombudsman in Norway and Denmark, and also in Sweden, is the work with cases on the freedom of information. The right for journalists, for the public, to see public documents. If a request to see a document is not accepted by the government, a complaint can be made, and a complaint can also be made to the Ombudsman. And the Ombudsman is playing an important part in these cases. And in these cases, I met some skepticism from time to time when I said that this should be this document. I cannot find it right that you close it. You should disclose it. You should give it out. And they do follow the opinion of the Ombudsman mainly, and but it is also with some bitter comments from time to time. But no conflict between the institutions. But that was a deviation from my manuscript. I must therefore go back to my manuscript, which it can be difficult to find what it was. Because I was saying a few things about the courts, the relationship to the courts in Sweden. But now I would like to say a few words about all the ombudsman schemes that have sprung forth after the establishment of the Parliamentary Ombudsman institution. I mentioned that initially in my speech too. And we have in the Nordic countries a numerous appellant and supervisory bodies, and the ombudsman title is used in many of these. The word and designation ombudsman has become very popular, so popular in fact that the situation can be somewhat confusing. However, public administration is also comprehensive and complex, and this is something we must live with. The institution of parliamentary ombudsman plays an important role, covers a specific requirement, and promotes the rights of citizens and other different interests. And one important thing, you can go to court with your case if you're not content with the decision of the administration. You can go to court, but then you need a lawyer. It costs a lot of money, and it can take a very long time. Going to the ombudsman doesn't cost a kopeck. It's free. It can take some time. It should be quicker than it is, but it is better than going through 3 instances of courts of law. But with his firm roots in the law and his ties with the legal profession in public administration and the courts, the ombudsman may be regarded as a quasi-court. It must be easy for citizens to approach the institution, and the institution must work efficiently and thoroughly in a serious and straightforward manner. Case processing must always be correct, simple, and in writing, and formality must not be taken further than requirements demand and confidence makes necessary. Confidence in both public administration and in the country's citizens is an important factor. Finally, I shall say a few words on the Ombudsman and human rights. Several human rights conventions are now transformed into Norwegian law. This year, many important human rights provisions were also incorporated and transformed into the Norwegian constitution. People have the right and possibility to go to the courts to have their rights. The judiciary plays an important role in this respect, but also the Ombudsman will in his investigations and opinions look to the human rights obligations. Thank you for listening.
Colleagues, it's time for discussion. You are welcome. Stanislav Avramenko, Rostov-on-Don. My question: Ombudsman may be a lawyer who represents in court his custodian, and if he controls the judge, in other cases where Ombudsman himself represents his client, he may somehow use his status to press upon the judge, and the judge would satisfy his demands. Is there any control mechanism as far as this is concerned?
Should be objective and neutral. So the Ombudsman shall not represent the complainant or the citizen who is making a complaint. He's not representing him. He's not an advocate for the citizen, but he shall consider the case on an objective and neutral way.
Так, Станислав.
Stanislav. Stanislav Stanskih, dear Arne, thanks for the lecture. It seemed to me unusual that the same person, like in your case, may be an ombudsman for 6 times. The trend in the world is different in the constitutional regulation. There are certain limitations related to occupying such positions. In many republics, there is such a limitation. So the head of the state, for instance, cannot occupy his position for more than 2 terms. Please comment on your own case. Of course, there are categories like judges who occupy their positions until they reach a certain age level. But ombudsman is not a judge. Thank you.
I shall try to be objective and neutral to your question. I think 6 times was pretty much, too much, really. I was 43 when I was appointed the first time. And I thought, well, a second time could be okay. But I was unanimously appointed all times because they tried to find a candidate who will have the support of all the representatives of Parliament, from the far left to the far right. So you might say, well, the ombudsman must be a kind of a paper tiger or a toothless person. I think too that 6 times was pretty much, and in Denmark, my predecessor here, Mr. Gammeltoft Hansen, he was for 25 years, but he resigned in 2011, and after his appointment, the law of the ombudsman was changed. So now there should only be 2 periods. So that's the outcome there. And there was some discussion in Norway also now, but the parliament said, no, we will not change the law, because they have the opinion, I think, that the parliament should be should have no binding rules on that. They should be the upper law of what you say about Parliament in Britain.
In Britain, it's different. Parliament is supreme.
Yes, Parliament is supreme, and that is also the attitude in Norway. They would say, but in the corridors, they said that the new appointed ombudsman should not take into consideration that he should sit as long as his predecessor. But we have one rule, and you know, pension schemes are always interesting, and it is a rule in Norway saying that after 2 periods you have full pension rights. So I could have quitted many years ago and still.
Well, you have full pension rights.
Yes, I have full pension rights now, but so it is in the law, I think, a kind of they presuppose that 2 periods is enough, and my predecessors were sitting for 2 periods. So, so my answer to your question is that it's not likely that we'll have them. And in many other jurisdictions, this is quite impossible to think. I think in the Nordic countries, it's a special experience.
Сударыня, вам слово, прошу.
Елена Лукавицкая, Novgorod. Thanks for a very interesting report. It's for the first time I found out that Ombudsman is a Norway ancient word. That was very interesting. I'm interested in practical issues. More or less, I understand what you do at the regional level and what you face. In your practice, what are your problems at the first place, second place, and the third place? I am a sociologist and I'm interested in this. On the basis of your legal practice, did you initiate certain amendments to law, or did you initiate certain laws? And what, if the answer is yes, what these laws were about?
Thank you. And let me first say that the Ombudsman work is not a one-man work. The Ombudsman has a staff of in Norway of 35 lawyers and around 50 or 60, between 50 and 60 persons in the office. In Denmark, it is much more. It's 50 lawyers and nearly 100 staff. The number of complaints received is 3,000 in Norway. And in Denmark, it's a bit more than 5,000. 50% of the complaints, that is about 1,500, are rejected because they are outside the powers of the Ombudsman. If you make a complaint against the courts, the Ombudsman cannot deal with it. If you haven't used the administrative complaint possibilities, you must do that first. But what kind of cases is your and all kinds of cases, all kinds of cases dealt with by public administration. So if you apply for a building permit and it is rejected, you can make a complaint also to the Ombudsman. And the Ombudsman has a lot of such cases. If your neighbor is allowed to build a house and you don't like it, you can make a complaint to the Ombudsman. And the Ombudsman can then go into the administrative handling of the case. Cannot decide whether it is right in connection with the or to the neighbor and so forth. But we'll go into the building, the case handling. Taxes, all kinds of taxes related to citizens. It can be value-added tax, it can be income tax, it can be tax on property, all kinds of such cases. Social security, pension questions, and other kinds of questions. Alien issues, questions. People applying for coming into Norway for family reunification or other reasons. They can come to the Ombudsman. All kinds of police matters. If the police deals with you in an improper manner, if you can go to the Ombudsman and complain to him. The Ombudsman has for several times made investigations on the using of custody. And we have found out that the police is not dealing with the custody matters in a proper way. So we have a lot of, and prison matters. I remember I was in Russia many years ago. I think it was 20 years ago. And it was the ombudsman at that time was Sergei Kovalyov. And I asked him if I could see a prison. Oh, yes. So he took me to a prison, to the prison of marine sailors, or yeah, yes. So I had the opportunity to see that, and we also make. So we do investigations and inquiries on prison matters, and receive also complaints from prisoners. We also have all kinds of cases related to education, schools, both primary schools, secondary schools, universities, and student financing. Also, questions about that. So it is a whole range of questions. So the answer is everything. But these I now mentioned are very practical, and it is not. And yes, let me also add that people applying for jobs, for work in public service, not getting them, they can also make complaints to the Ombudsman. And we have such cases also. All right.
Продолжаем, коллеги.
We move on. Julia. Thanks for your presentation, Yulia Счастливцева, Chelyabinsk. You mentioned several times that the Ombudsman institution conducts its own investigations. What are your responsibilities for making such investigation, comparing with prosecutors, with judges, and what methods do you use when you conduct your own investigations?
Investigations are made either on the basis of complaints, normally complaints regarding decisions. They will be conducted in writing. So the Ombudsman will write questions to the administration, ask for answers in writing. So that will be fairly formal investigations. The investigations in prisons and police custody institutions or psychiatric hospitals, which also the Ombudsman inspect or control, then that will be done both in writing and with on stage or on scene inquiries, but not so formal, in an informal way. But the public administration, the administration or of the hospitals, of the police institutions, prisons, will always have the possibility to answer questions before criticism from the Ombudsman. But the investigations are, in practice, very informal.
Так, продолжаем. Прошу.
Okay. Olga Fadeeva, Yugra. My question in your rich experience, was there any case when you made a decision in favor of a citizen that his rights were violated, and these decisions were not responded by the administration? In our case, well, I personally have such cases when the judicial system ignores the opinion of ombudsman, just ignored, and it was not even mentioned in the court resolutions. Did you have such cases?
Yes, yes. Not so many, but one particular case I remember. It was an advocate who lost his license, and because he had not his accountancy declaration in order. So he put that in order and said to the administration that now I will have my license back. And then the ministry said, no, you cannot have it. You cannot have it until 1 year has elapsed. So because you didn't do it properly, you have to wait a year. And I said, there's no legal foundation for that. According to the law, he's entitled to his license when he has put these things in order. But the ministry did not accept it, my decision. So they went. The advocate went to court, and he lost the case in the first instance. And the ombudsman was not very. He was a bit criticized too. But then he appealed to the appeal court, and the appeal court also gave the ministry. They decided in favor of the ministry. But then he went to the Supreme Court. And what did the Supreme Court do? The Supreme Court made a decision in favor of the Ombudsman. Yes, it was 4-1, but but that is a very particular case, a very special case. But because mostly the administration will accept the recommendation.
Так.
Timur Ужахов from Ingushetia. A question and a brief comment. My question, have you ever participated in Breivik's case? And sorry for probably being tactless. I was in Norway, and I heard the story that Norway received autonomy when Swedish king lost a card game. Is it true?
North of Scotland, because the king had given away to the Scottish king sometime, and he didn't get it back, something. But I haven't heard that he lost that in a card game.
These gifts can have terrible consequences.
Yeah. But you mentioned the Breivik's case. Well, I should not comment on concrete cases. Normally, the Ombudsman should not either confirm or the opposite of a case. But I think it has been said in the newspapers that there is a complaint from him on the conditions he's now being, in prison. So, as you know, he was considered to be sane, and he got 21 years of confinement. So there he is, isolated, and he's not with other prisoners. So, and this is, let me say that his conditions in prison are under the scope of powers of the Ombudsman. So the Ombudsman can deal with his case. Yes.
Про проигрыш опять.
About the loss again, Timur, your guess, allow me to reconsider the Crimea situation. You, as Ombudsman, do you understand everything in the case of Breivik? Do you have questions for yourself?
Many questions. And it is a case, of course, which is very, questions of principle. Many questions you can ask about this case, about the penalty, how he was treated in the process in court, and so. But have you specific questions that you want me to comment on?
Тимур, я не смогу, к сожалению, я не смогу.
Unfortunately, we would not foster this dialogue any further because I have 130 people who would like to contribute to the discussion. Sochi, please. Anna Martinova, Sochi. Arne, in Russia since certain time we have an Institute of Ombudsman, but as distinct from the West European system, we have personalization of ombudsman on the areas of activity. We have a child ombudsman, Pavel Astachov, for instance. What is the system of building of Ombudsman Institute seems to you more efficient for Russia? And maybe considering the scope of our country, we need separate ombudsman by regions. Or we have to stick to the European system and centralize this institution.
Yes, I was thinking about this under your intervention this morning about the question on unitary states and federal states, and we have a federal ombudsman in Spain. It is but they are also ombudsmen in the regions of Spain, in Catalonia, for instance, and in the other regions. But in Germany, they have no ombudsman on the federal level, but they have ombudsmen on the regional levels. But in the federal parliament of Germany, they have a petition committee which acts like a kind of ombudsman. In Russia, there are ombudsmen in regions here, I understand, but you also have a federal or an ombudsman on the federal level, but that he's an ombudsman for human rights. But these institutions, they are, as I told you, very, very different. Because the political systems are very different. the administrative systems, the constitutions are very different. And you have to make these, to measure these institutions. You can't transplant an institution from one jurisdiction to another. So the Nordic ombudsman, or the West Nordic type of ombudsman, could not be transplanted into Sweden and should not definitely be transplanted to Russia or Germany or Spain and so forth. But the core characteristics of the ombudsman institution, I think, could be exported and could give you some ideas of creating an institution according to your needs and your conditions. So, but it is an institution to bring equity and fairness into the law, to say it briefly. But so this is not a revolutionary institution, but then it could be scrapped at once. But so well, was this an answer?
Так, Вахтанг, у вас был вопрос, да?
A question from Georgia. I'm Vahtang from Georgia. Thank you very much. It's really very interesting. Many representatives of this class would envy Norway and Scandinavian countries in the area of your ombudsman institution. I'll take an example from my country. We have this institute of ombudsman since the 90s, and after the Rose Revolution, the head of this institution was the representative of NGO, who actively took his role. He criticized the authorities a lot. In the events of 2007, he was beaten by the policeman himself. Ombudsman was a victim of the state terror, let's put it this way. When Saakashvili came to power, there was someone who was close to his power, and he received a post of the minister later. And that really means that reports made by the first or second ombudsman in parliament, they were not considered seriously. You are an experienced person in this field. What international instruments may be used to influence positive results so that the word of ombudsman was taken into consideration and his recommendations were taken into consideration, because internal mechanisms are pretty poor in our country?
Well, that was a very difficult question. So far, the ombudsman, at least the Nordic ombudsman, have been very, very skeptical to go into matters outside their jurisdictions. They see that they have domestic duties, they have domestic tasks, and should go into them. But they are from time to time asked to support other institutions outside, and very skeptical to that. But that is not an answer to your question, because your question would be, are there other means to support an ombudsman who has suffered injustice or who has not been respected as he should? Well, politics is, and the press, not at least, that is, it can be effective means. But to find legal or formal means, I think is very difficult. But I should like to add something about, because I mentioned to you that the ombudsman of the Nordic countries are lawyers or have legal background, and I asked once the then parliamentary ombudsman of Ireland, Emily O'Reilly. I asked her, how is it possible, and she is a political journalist of background, and I said, is it possible to be an ombudsman without being a lawyer? And she laughed at me, and ever since in conferences I've been mocked by her. Last year she sent me an email telling me that now she has an honorary degree of law. So no, so of course it is possible to be an ombudsman without being a lawyer, and particularly in other jurisdictions. But in the Nordic countries, it is effective and good to have a lawyer, but other places it could be more effective and to have other. And now Emily O'Reilly is the EU Ombudsman, the Ombudsman of the European Union. So, back to your question, the legal profession, could they internationally be of support? Of course, it's this has something with the rule of law to do. And we have an international law commission, we have other international organizations who could be of help.
Сударыня, вы, прошу.
Mr. Ombudsman, please remember to give your name. I'm sorry, Anna Baydakova from Moscow. Have you had any cases when you as an ombudsman would disagree with some decisions of the government, with some laws that were adopted by the parliament, and that you entered a discussion maybe, or challenged, maybe had some showdown with the government? And if so, how did you resolve such cases?
Да, бывало. Я могу упомянуть один случай. Не так много лет назад он произошел. Я получил жалобу от журналиста. Кто не получил какой-то документ. Это было мнение письменное, высказанное специалистом, юрисконсультом правительства, какого-то министерства, и журналист хотел этот документ увидеть. И...
Канал сменился, пятую попробуйте, да? Все нормально. Все нормально. Если можно, ответ сначала. Ответ.
Proceed. Okay. Yeah. The journalist was rejected to see the document, and the journalist made a complaint to the ombudsman. And I asked the ministry to give me the document so I could see that the decision was right. But the ministry said, no, you cannot see it. We will not give you, we don't disclose this to you either. And I said, well, I have the duty of silence. I cannot tell anybody about it, but my mandate is to control that the public decisions are legal. So I want to see the document. So I can't do my duty. And it went all the way up to the government, to the minister. And the minister said no. And then I made a special report to Parliament and said that I cannot see a document, I cannot fulfill my duties as Ombudsman, I cannot control what I'm asked to control. And the Constitutional and the Control Committee of Parliament unanimously decided that the government should give the document to me. So I got it at last, after a struggle with the government. But and the government just accepted it and gave it to me. So, but this is not a typical case. It was a very special case. But I think it was very important for as a precedent. And after that, the law was changed. So now it is quite clear, stated in law, that all documents should be given to the Ombudsman.
Can I just clarify one point? Were there really some confidential, secret documents, and did the journalist finally get? What were the reasons that they refused originally to give this document to the journalist? Were they confidential or secret, or what?
A secret was the ministry should have the right to consult the ministry's lawyer, the legal opinion. So it was they were entitled to close it, to reject it. So it was a matter of principle for the Ombudsman, because I couldn't decide in another way. I had to accept that it was legal, the decision by the government, but I wanted to see it, and I wanted to confirm it on the basis of a real investigation.
Коллега, пожалуйста, называйте себя.
Dear colleague, please remember to give your name. Oleg Agafonov from Rostov-on-the-Don. Thank you very much for the informative presentation. My question, please. Do you receive threats from the law enforcement agencies and from the government for what you do? Do you often face threats to your life? And if you do, how do you cope with this? Please give me examples from your practice.
Well, the answer is no. I don't receive complaints, not really complaints, or threats. Of course, I receive complaints. Oh, yeah. And I also receive threats. Yes. And they have such, and one of the most serious threats I received during my practice was from a lawyer. And threatening with things which is very, which can be legal, because they say that if you don't decide this case in favor of me, I will go to the press. Well, do that. Go to the press. But it's meant to be a pressure, a threat, because in that case, the advocate thought that it would be embarrassing for me, for the Ombudsman, to have this case disclosed in the press. But it wasn't. It was a. And the paradox was that he had, or his client had, a case, but I hadn't the means to put it through. So I had to try to persuade the public administration, but he was not content with that. Other kinds of threats, yes, there has been, but my staff, who are in contact with the complainants, they sometimes receive threats, and we have to cope with them. But I think the administration, the public administration, and the officials and the public servants, they are threatened much more, and they are. We have also tragic examples of public servants who have been killed. So, and of course there can be some threats, but then we will have some. Well, either we we report it to the police. We must do that. So we have certain procedures.
Анна, прошу вас.
Anna, please, you now have the floor. Anna Vilikok from Leningrad. She speaks English.
I wonder why countries such as Norway that have independent court and well-developed judicial system have an extra institution aimed at human rights protection, while countries where you see almost no chance to have a positive court decision, there seems to be almost no demand from grassroots, from civil society to implement the efficient institution of ombudsman. For example, in Russia, people and NGOs tend to ask European Court for Human Rights for help rather than the ombudsman. What do you think?
Yes. You think of having a Human Rights Commission, for instance. That is a question we are now discussing in Norway, and probably we will have such an institution later. And I think to have a Human Rights Commission is a wise thing to do. The politicians are a bit reluctant because it costs money. So they thought for a long time that they should put this Human Rights Commission cases to the Ombudsman. But I think it is important in a Human Rights Commission to have representatives from NGOs, from all part of civil society. So I think, and that is now what is going to be the outcome in Norway, probably. In many other jurisdictions, you have human rights commissions, and they work side by side with the Ombudsman. Recently, I was in Tunisia, and they have an Ombudsman, and they have also a Human Rights Commission, but they have also a Commission for Sustainable Development. So that is a new issue for a new institution to take care of the sustainable to have the sustainable development, a commission for that.
Прошу, коллега, вам слово.
Dear colleague, you now have the floor. Alexei Yermakov from Golitsyno, Moscow region, from here. It is well known that Norway is a country with high living standard and level. So many people who travel from other countries wish to arrive there and live there and settle down. I want to know, as a human rights activist, do you defend people who immigrated from other countries, immigrants, who to a certain degree are then in conflict with the Norwegian society, may be reluctant to assimilate, and whether it serves the interests of the citizens of Norway to have them, and how in this position can you tell us what is your attitude on this? What is your take on this?
Yes, we have cases or complaints from people who want to be in Norway or also who are expelled, who are not allowed to stay in Norway. And they make complaints both to the Ombudsman and they go to court. Let me say, my point of view is, or both as Ombudsman and for that it has not changed after having been Ombudsman. We should base the decisions and investigations on the law, on the current law. That should be done. Now our system is very both flexible and also very liberal, I would say. So, we have some cases, or particularly one case, which has been talked much about in the press, but which has not been much to the Ombudsman, where a man still is in Norway who, according to all decisions, should be outside. But it is not possible to send him outside Norway because we don't know. We cannot send him to a safe place. So therefore, we are stuck. For instance, in Norway, the death penalty is abolished. And if we expel a person who is likely to be sentenced to death or is likely to be treated inhumane, we should not refuse him to stay in Norway.
Вопрос из Польши.
A question from Poland. Dear colleague, you now have the floor. Jakub Bergman from Poland. Speak English.
When Norway will eventually join the European Union?
Well, I should like to have some politicians from Norway here. I don't know if it is likely to happen. Norwegians are very skeptical to the European Union. So why? Well, there are different opinions on that. Somebody say that we have oil and gas and want to keep that for ourselves. I don't think that is the whole truth. But we have such ideas on independence that I think it's more a psychological question than other question, because let's say we are not a member of the European Union, but many say that in the areas we have the European Economic Agreement, we are the best pupil in the class. We transform the EU rules before the EU do it themselves. So we are very clever.
Why are Sweden, Denmark and Finland members of the European Union and not Norway?
Now, because well, he asked why Finland, Sweden and Denmark are members and not Norway. Well, I really don't know why. It is a very difficult question. But they are not so, well, they don't have the oil and gas. That is one thing. That is one difference. No, I'm very honest now. Well, but then the Norwegian mentality is also probably a bit different. We gained, we tried to gain our independence in 1814, but we were forced into the union with Sweden. But not quite forced, because there were some leading Norwegians who were very eager to get in the union with Sweden too. But then in 1905 we gained the independence from Sweden, so we are a relatively young nation, so wanted to keep that way.
Excuse me, you don't mind if I ask another question?
Вы хотите уточнить?
Не, я хотел, да.
Do you want to clarify your question?
Taking into consideration your independentism, how come that you joined NATO in the end? For example, Sweden, which is your neighbor, did the opposite thing so far. So this is quite strange.
This is definitely outside my scope of power as Ombudsman. But now I'm not an Ombudsman, so I could freely answer your questions. Well, that was in 1949 that Norway was a member of of NATO, and that was the situation then. Of course, that was the reason for that. 1972, the question of membership of the European Common Market came up and then was rejected after a referendum. It was 51% against and 49% for. And in 1994 we had a new referendum, also rejecting, but then with a bigger majority against. In 1972, we did not have the oil and gas as we have today. So the explanation then, I think, was much due to the Norwegian mentality, which still is there, although it is a combination now with oil and gas. But we have been very, very lucky with having a good economy, with full employment, and so economically people are very content, and they are in such a situation they are reluctant to make a change, and they also see the problems which the European Union face. So they are in a different position than other countries that recently have joined the European Union.
Есть еще более странные случаи.
There is another stranger case. Russia, for example, is not a member of NATO or EU. You won't believe it. Artyom, you now have asking the last question. Speak English.
From St. Petersburg. Thanks a lot for being with us. And my question is about the role of juvenile ombudsman in northern countries, because I've once met with Kaisa Maria Aula. She is a juvenile ombudsman in Finland. And now in Finland, as well in Sweden, as well in Norway, as well as even in the UK, there is a Muslim community, there is a community of immigrants, and one of the questions is not only how to integrate them into society, protecting their rights, but the other question is how to protect, for example, children who are children of these immigrants in these families, because, for example, in Britain there is a big problem of inadequate treatment in the families with, for example, girls in Muslim families. I know that something the same problem is in northern countries as well with these immigrant families. So do you have some understanding of how to treat these families in order to provide security and freedom and European values for those children, and also not to blame the traditions of those immigrant families? I mean, for example, to be very concrete, the problem which is widely discussed now in Britain, the problem, I don't remember the term, I'm not sure about these words. They discuss a lot the female, so the rights of young girls, yes, in Muslim families. Do you have this in northern countries?
Yes, we have such problems, and but I would say that the problems you mentioned are problems not only concerning the families of other ethnic groups. We have the same problems with Norwegians, yes, and Scandinavians. where the authorities have to go into the families and give them or support, and sometimes also to take the children away from their parents. But of course there are also special problems related to the ethnic groups, and it is a much discussed question, and I must say it comes to a on the edge or on the apex, or that is the when parents are rejected asylum, or they are not allowed to stay. They must leave the country. And in many cases, they have been allowed to stay in Norway for a long time, temporarily, until their cases have been decided. And their children are taken to school. They have friends. They learn Norwegian. They speak Norwegian. And then they shall be taken back to their country. And then the children's ombudsman in many cases, but also the children or the juvenile authorities say that you can't do that because that will be detrimental, that will be not good for the child. And you can't separate the children from their parents. So their parents stay with their children. That is, yeah.
Спасибо большое.
Thank you very much. Dear colleagues, since a while ago, Norway is now getting great understanding of what the school does and our efforts in terms of civic enlightenment. And the school runs several projects with our Norwegian partners. The very fact that we now had such an excellent expertise from Norway, this is actually the outcome of these projects that we implemented. I think we have listened to a wonderful presentation by Mr. Fliflet, and I would like to, first of all, I would like to request that you should congratulate him on his first presentation here. And secondly, let us express a hope that it is not the last presentation and this expert will join us again and again.
Thank you very much. But me also, so my thanks to the audience and for all the questions and comments you made. This has been such an experience, which is, in my 24 years experience, very, very special. Thank you very much.
Спасибо. Приятного аппетита, коллеги.
Enjoy a meal, colleagues.
Yes.
It was very interesting.